Reading BARBRI outline, real property. Reading on page, I think 37, maybe 36. I don't know anymore. I was in the trust section. We read about the fertile octogenarian, the unborn widow and unborn widower, and options and rights of first refusal. I mean, I think we're actually in. I actually have no idea where we are. I left a long section. Options and rights of first refusal. Options, an option creates in the optionee a right to purchase property on terms provided in the option. Options are typically considered to be assignable unless the parties provide otherwise, and thus are subject to the rule against perpetuities. If an option is structured so that it might be exercised later than the end of the rules period, it will usually be held void. There's some examples here. So, assignable unless the parties provide otherwise, and thus are subject to the rule against perpetuities. So, does the rule against perpetuities only apply if the option is not assignable? Or maybe I'll read the examples. A is a subdivision developer and gives B an option to purchase a lot in the subdivision to be exercised within 60 days after the city council grants approval for the filing of a subdivision plat. While the parties may expect this to occur soon, it is possible that it will not occur within 21 years after any life in being at the creation of the option. Hence, the option may be held void. O conveys to A and her heirs an option to purchase Blackacre for $25,000. This option is not limited to A's life, but can be exercised by A's heirs and their heirs long after A's death. Thus, the option is void. Reasonable time limit may be inferred. A significant minority of courts in applying the rule to these interests will construe the option as lasting only for a reasonable time, which is invariably less than 21 years, and thus will uphold it. Under this view, the option in example 1 above would be sustained on the ground that the parties intended it to expire if the city council failed to act within a reasonable time less than 21 years. Similarly, if the parties to the option are natural persons, some courts construe the option as lasting only for their lifetimes, hence it is valid under the rule. Furthermore, the uniform statutory rule against perpetuities excludes options in commercial transactions from the rule's application. Options connected to leaseholds. If a tenant under a lease has an option to purchase the leased premises during the lease term, the rule is not applied no matter how long the term. If a tenant assigns the leasehold, the option generally is considered a running covenant, exercisable by the assignee in the absence of contrary intent. However, a tenant may attempt to transfer the option to some other party, thereby separating it from the leasehold estate. While some courts do not permit the option to be transferred separately, most courts hold that the transferability of the option depends on the original party's intent when they entered into the lease and option agreement. If the court finds that the option has been separated from the leasehold estate, that it is no longer exercisable by the tenant, the option becomes subject to the rule against perpetuities. Rights of first refusal. A right of first refusal or preemptive right gives the holder the right to purchase the property if the seller receives a third party's offer to purchase, usually on the same terms as that offer. In contrast to options, rights of first refusal in many states are presumed to be personal to the holder and thus not assignable unless the instrument indicates otherwise. Malone versus Flattery, Iowa, 2011. Non-assignable rights. Non-assignable rights of first refusal are usually not subject to the rule against perpetuities, but rather are governed by the rule against restraints on alienation. In some states, however, rights of first refusal are subject to the rule against perpetuities in the same manner as options. Application to the rule of application of the rule to class gifts. Bad as to one, bad as to all rule. The general principle that the rule does not invalidate interest that vest within the perpetuities period does not apply to vested remainder subject to open. The class gift rule, sometimes called the all or nothing rule, requires that the class must close within the perpetuities period, and all conditions precedent for every member of the class must be satisfied, if at all, within the perpetuities period. If it is possible that disposition might vest remotely with respect to any member of the class, the entire class gift is invalid. Example, stay for life then to such of A's children as live to attain the age of 35. At the time of this disposition, A has two children, X age 38 and Y age 33. Thus, the state of title is that Romanet 1, A has a life estate, X has a vested remainder subject to open. There is a contingent remainder in such of A's children as live to attain the age of 35. Romanet 2, the remainder to A's children violates the rule. The transferor has a reversion in fee. While X's remainder is vested subject to open, it is not vested for purposes of the rule. Here is what might happen. A might have another child, Z. Before Z attains age 14, A, X, and Y might die, etc. The gift with respect to any afterborn child of A clearly violates the rule. Under the bad as to one, bad as to all class gift rule, the entire class gift is void. Why does the class closing rule not save the gift? Because X is already age 35. Doesn't this mean that the class will close on the life tenant's death? The answer is yes, it does, but this does not help. Although we will close the class at that point, the class is closed. The class as closed might include the afterborn Z, who might be under age 14 at that time, and it still might be more than lives in being plus 21 years before Z's interest might vest. Example number 2, to A for life, then to A's children for their lives, and on the death of the last survivor of A's children to A's grandchildren in fee. At the time this disposition takes effect, A is alive and has 2 children and 3 grandchildren. A has a life estate. The 2 children have vested remainder subject to open in a life estate. And the 3 grandchildren have vested remainder subject to open in fee. The remainder to A's grandchildren is void because every member of the class will not be ascertained until the death of the survivor of A's children, and that surviving child might be born to A after the date of this disposition. Then all of A's children and grandchildren who are lives in being might die, and 21 years after their deaths, this afterborn child might give birth to a child, GC-4, although GC-4's interest would vest at birth. Under the hypothesized facts, it would vest remotely. So, like, this whole entire example just threw me when it said that A has a life estate. The 2 children have vested remainder subject to open in the life estate. Well, to A for life, then to A's children for their lives. Life estate to their children for their lives. Vested remainders subject to open in a life estate. Okay, well, that's why it threw me, because I've absolutely never seen that estate before, that interest in an estate before. So, everything else they said, like, just didn't go in. So the rest of this grant is, and on the death of the last survivor of A's children, to A's children in fee. On the death of the last survivor of A's children, to A's children, grandchildren in fee. I mean, it seems like it seems like it fails rap, but the reason why it seems like it fails rap, remembering rap, is no gift is good unless it must vest, unless it vests, if at all, within 21 years of being of alive and being at the time of the grant. So it must vest, if at all, within 21 years of a life and being at the time of the grant. So at the time of the grant, A is alive and has 2 children and 3 grandchildren. So let's just say the last of the 3 grandchildren, like the last born of the 3 grandchildren, is the measuring life. Since measuring life wasn't very clear as to which one it could possibly be, it just said it had to be like related to the grant. Let's just say that were the case. Then is all this stuff going to happen within 21 years of that person's life, where all of A's children die? And it's possible that it doesn't. And so as to all in the class, the grant is destroyed, is void. The gift is void. So is that what they said? It would vest remotely. Okay, so did they say that the life estate, the 2 children of a vested remainder subject to open in a life estate, and the 3 grandchildren have a vested remainder subject to open in fee? The remainder to A's grandchildren is void, because every member of the class will not be ascertained until the death of the survivor of A's children, and that surviving child might be born to A after the date of the disposition. Then all of A's children and grandchildren who are alive and being might die in 21 years after their deaths. This afterborn child might give birth to a child. Okay. I feel like there needs to be a better rule, like the rule against perpetuities, that actually says that your gift can't include an afterborn child in a class, if that's actually the rule. Because what they're most afraid of, I mean, unless there's more to it, like, because my analysis of it was different than this, but like, if they're most afraid of the fact that after I guess it depends on which one of these they're calling the measuring life. They didn't go with the youngest person as the measuring life like I did. They said every member of the class will not be ascertained until the death of the survivor of A's children, and that surviving child might be born to A after the date of the disposition. So like, why doesn't the rule against perpetuity say that every life has to be ascertained at the time of the grant? Or is that always the case? Class closing rules may save disposition. In some cases, the rule of convenience applicable to class gifts can be relied on to save a gift from the rule. For example, class closing rules may save a disposition. So, for example, this is when the rule of convenience might save a gift, for example, to A for life, and on her death to A's grandchildren and fee. At the time of the disposition, A has 2 children and 3 grandchildren. A has a life estate and the grandchildren have vested remainder subject to open. As in the preceding example, A might have an afterborn child who might produce afterborn grandchildren. But there is one difference. Under the rule of convenience, the class will be closed at the time any member of the class can demand a distribution. Here, the death of A life and being. Consequently, all members of the class who will be permitted to share in the remainder will be determined on A's death. I mean, all of these concepts actually don't make any sense to me because I don't even really know how the rule of convenience arrives here, except that this remainder is going to be extracted from the entirety of the grant and be allowed to and a member of that class can demand a distribution. I just don't find it to be the case. Unless you're saying to A for life, okay, then to A's children for their lives. So what they're saying is when A dies, the A's children may demand a distribution of their life estate from A. Okay, I guess I understand. That's how the rule of convenience is going to apply to the first step in this equation, in this grant equation, to save that part of it, but it will the grant will still be, or the gift will still be void as to the grandchildren. So what happens? I think what would probably happen would be that when all of A's children die, that the gift goes to A, a reversion to A, which would mean that it would be distributed to A's heirs, intestate heirs, or testamentary gift. I don't know. And so it's just really confusing. Gifts to subclass exception. Separate gifts vest at different times. Each gift to a subclass may be treated as a separate gift under the rule. So that's what I was just grappling with. To pay the income to, here's an example, to pay the income to A for life, then to A's children for their lives. And as each child of A dies, to distribute the corpus to such child's issue then living in per stirpes. And as each child of A dies, to distribute the corpus to such child's issue then living per stirpes. A has 2 children at the time of disposition. In this case, the remainder to issue has been made by a gift to subclasses. As each child dies, his issue are to take the share on which he was receiving income. With respect to A's 2 children now alive, the class of issue then living will be determined on their deaths. The gift is good. If A should have another child after the date of the disposition, the remainder to such afterborn child's issue is void, because it might vest beyond the lives and being plus 21 years. Per capita gift exception. When there is a separate gift of a fixed sum to each class member, each gift is tested separately under the rule. This is the per capita gift exception. When there is a separate gift of a fixed sum to each class member. Each gift is tested separately under the rule. When there is a separate gift of a fixed sum to each class member, each gift is tested separately under the rule. Example, T's will bequeaths $1,000 each to such of A's $1,000 each to such of A's grandchildren as live to attain the age of 21, whether alive at my death or born thereafter. At T's death, A has 2 children and 5 grandchildren. Here we have a per capita gift to each member of the class. There is no problem of knowing within the perpetuities period the number of class members who share in an aggregate gift, and thus the size of each share. Here, the amount to be received by each member is ascertainable without reference to the number of persons in the class. The bequest is valid for all grandchildren by A's 2 children who were alive at T's death. This includes all future grandchildren as well as the 5 now on the scene, for all such grandchildren will reach 21, if at all, within 21 years after the parent's death. However, the bequest is void for any grandchildren by a child to A after T's death. Such an afterborn child cannot be used as a life in being. Perpetuities reform legislation. Most states have enacted one of the following types of statutes designed to eliminate some of the harsh results of the common law rule against perpetuities. The wait and see statute, I read this, under which the validity of an interest following one or more life estates is determined on the basis of facts existing at the end of the life estate rather than at the creation of the interest. A Cypress approach borrowed from trust law, under which an invalid interest is reformed to comply with the rule and carry out the grantor's intent as nearly as possible. A statute dealing with specific perpetuities problems, example, age contingencies, reduced to age 21, women over 55, presumed incapable of childbearing, gift to widow, presumed to mean the person who was the spouse on the date the gift was created, or, and lastly, the Uniform Statutory Rule Against Perpetuities, which provides an alternative 90-year vesting period. The Uniform Rule takes a wait-and-see approach in determining whether an interest actually vests within 90 years. Technique for analysis of perpetuities problems. In applying the rule against perpetuities, these 3 steps should be followed. I have the word Edwards written in the margin here. So, what did I just say? Technique for analysis of perpetuities problems. In applying the rule against perpetuities, these 3 steps should be followed. A, determine what interests are created. First, determine the interests are created applying the proper future interest labels as though there were no rule against perpetuities. B, apply the rule. Determine the measuring life for lives that can be used to show either that the interest must vest within lives in being plus 21 years or that the interest might not vest within that period. At this step, assume that there is no such thing as a perpetuities reform statute, for the statute is not brought into play unless there is a perpetuities problem. Apply reform statute. If the particular jurisdiction has a perpetuities reform statute that is triggered by the perpetuities violation, apply the statute to reform or save the gift. Part F, the rule against restraints on alienation. As a general rule, any restriction on the transferability of a legal, quote, as distinguished from an equitable, end quote, interest in property is void. The restriction violates the common law rule against restraints on alienation. Restraint on alienation means an express restriction on the transferability of property. Like the rule against perpetuities, this is a rule of public policy that is designed to prevent property from being tied up and taken out of commerce. Types of restraints on alienation. There are 3 types of restraints on alienation. Disabling restraints, those are void, under which any attempt to transfer is ineffective. Forfeiture restraints under which an attempted transfer results in a forfeiture of the interest, and promissory restraints under which an attempted transfer breaches a covenant. A disabling restraint on any legal interest is void. Examples. Property is transferred to A in fee simple with the added proviso that neither A nor any of her children shall have the right to transfer the land or any interest therein. Under this restriction, if given effect, it is not. Any attempted transfer would simply be ineffective. This is a disabling restraint. 2. Property is transferred to A in fee simple with the added proviso that if A shall attempt to transfer the land or any interest therein during her lifetime, her estate shall cease and title shall vest in B. This is a forfeiture restraint. And 3rd, property is transferred to A in fee simple with the added proviso that A hereby covenants that she will not transfer the land or any interest therein without the transferor's prior consent, written consent. Under this promissory restraint, if given effect, the remedy is injunction or damages for breach of contract. Part 2, under the rule against restraints on alienation, is restraints on fee simple. Total restraints. Any total restraint on fee simple, either forfeiture, disabling, or promissory, is valid, and the grantee may ignore the restraint and freely transfer the property. Partial restraints. A partial restraint is one that purports to restrict the power to transfer to specific persons or by a specific method or until a specific time. Reasonable restraints doctrine. 1. Although absolute restraints on fee simple estates are void, a forfeiture or promissory restraint for a limited time and for a reasonable purpose may be upheld. Example, A owns and resides in a house. He conveys a 1/2 interest in the house to his brother B, including in the deed a covenant that during their joint lifetimes each party promises not to convey this interest to any other person without the consent of the other party. This promissory restraint is limited to the joint lifetimes of the parties and is a reasonable way to ensure that neither party will be faced with the prospect of residing with a stranger. The restraint would probably be upheld. 2. Discriminatory restraints. Restraints prohibiting the transfer or use of property to or by a person of a specified racial, legal, or ethnic group are not enforceable. 14th Amendment, judicial enforcement of a covenant forbidding use of property by persons of a particular race is discriminatory state action forbidden by the 14th Amendment to the United States Constitution. See Shelley v. Kramer, 1948. Example, O conveys Blackacre to A and his heirs, and A promises that Blackacre will never be used or occupied by non-white persons. Thereafter, A sells to B a black man who moves in onto Blackacre. O sues for an injunction prohibiting B from using Blackacre and sues A for damages for having sold to B. Injunction and damages are judicial remedies ordinarily available for breach of covenant. The court cannot grant O either the injunction or damages because such judicial action would be state action transferring with B's right to enjoy property free of racial justice. Fair Housing Act. Discriminatory restrictions may also violate the Fair Housing Act of 1968. Recording a deed with a racial restriction is prohibited by the act. Now, restraints on the life estate. Legal life estate. Forfeiture and promissory restraints on life estates are valid. A life estate is inalienable as a practical matter because few would be willing to pay full value for an estate of uncertain duration. Thus, little is lost by giving effect to the transferor's intention to restrict the estate's transferability. However, disabling restraints on legal life estates are void. Equitable life estate. The rule applicable to restrictions on equitable interest, example, those held in trust, is the exact opposite of the rule applicable to legal interests. Spendthrift clauses, which are true disabling restraints, are given effect in the great majority of American jurisdictions. See the trust outline. Part 4, restraints on future interests. Restraints on vested future interests generally are valid only to the extent that restraints on present interests of the same type are valid. And disabling restraints on all future interests are void. Vested remainder in fee simple. Any total restraint on a vested remainder in fee simple, either forfeiture, disabling, or promissory, is void. Partial forfeiture and promissory restraint on vested remainders in fee simple may be upheld if reasonable. Partial forfeiture and promissory restraints on vested remainders in fee simple may be upheld if reasonable. But disabling restraints on all future interests are void. Okay, so vested remainders for life. Forfeiture and promissory restraints on vested remainders for life are valid. Contingent remainders, the law is unsettled as to the validity of forfeiture and promissory restraints on contingent remainders. Thus, this issue is not likely to be tested. Other valid restraints on alienation. Reasonable restrictions in commercial transactions. The courts tend to uphold restrictions on transferability that arise in the context of a commercial transaction on the theory that the restriction appears in the agreement entered into by the parties. It is a product of their bargaining and presumably serves the useful purpose in facilitating the parties' objectives. This restriction on transferability that are part of a bargain for agreement, as distinguished from a donative transaction, are valid. Examples are O borrows money from M Bank and gives bank a mortgage on land. The mortgage provides the land shall not be transferable by O without M's consent, and that if the land is transferred without consent, the entire indebtedness shall be accelerated and shall become immediately due and payable. This due on sale restriction on transferability is reasonable because M has an interest in proving who shall be the transferee of the land in which it has a security interest. A, B, C, and D, this is another example. Each own 25% of a stock in a closely held corporation. The articles of incorporation provide that no shareholder shall transfer her stock without the consent of a majority of other shareholders. This restriction on transferability is valid because due to the closely held nature of the business, the shareholders have a legitimate concern over the identity of their associates. Last section, B, options and rights of first refusal. The right to have the first opportunity to purchase real estate when it becomes available, or the right to meet any offer, is valid if reasonable, for example, by specifying fair market value or other reasonable price. This comes from the Restatement Third of Property Servitudes 3.4. And actually, C is the last section, restrictions on transferability of leaseholds. A provision in a lease prohibiting the lessee's assignment or subletting of her leasehold interest without the consent of the landlord is given effect in all jurisdictions. So the next section is going to be concurrent estates. And it's talking about the joint tenancy. The 4 unities needed are time, title, interest, and possession. And there's this modern law sort of aside that the above requirements have been eroded in some jurisdictions by statute. In some states, an owner can create a joint tenancy in herself and another by a single deed. She need not use a straw man conveyance, even though the unities of time and title are not satisfied. Similarly, as indicated below, a number of transactions are no longer found to sever a joint tenancy despite the seeming absence of continued unities. Express language is required to set up a joint tenancy, for example, with right of survivorship. Today, when 2 or more persons take joint tenancies are disfavored under modern law, so there must be a clear expression of intent to create this estate, or it will not be recognized. The usual language is what I just said, joint tenants with right of survivorship. Today, when 2 or more persons take property by a single conveyance, a tenancy in common, not a joint tenancy is presumed. A joint tenancy results only when an intention to create a right of survivorship is clearly expressed. So, severance, talking about the partition here. Landlord tenant will begin in a couple pages. all of that needs to be read because I don't believe it's been read to this point. Any other recording, unless I'm crazy. So what did I read? Like, this is it's gonna really take us very far. Over here to still going. Fixtures. Okay. So it's not gonna be for another 20 pages that we're done reading this outline, which is nuts. So I'm gonna end this here. Sorry.